Good evening. Hi, everyone. My name is Gary Elizio. This is Keith Button, my colleague. We're both from Shaffer Law Firm in Meadville. And tonight we're going to be talking to you about powers of attorney, advance directives, and wills. And if you don't take anything else from our talk tonight with you, the one thing you should know is these are important. They don't cost a lot. They don't take a lot of time to get in place for yourselves, but they're definitely something that you every person, every adult really needs to have for themselves. No, we won't talk to your backs, right?
And just to let you know, we'll work off the TV screen for the PowerPoint, but when we get to the end, we have handouts of the same slides that you can take with you if you want to be able to have them for reference later on too. Okay? So we'll get started, and I'll take the first leg, and we'll move to the first slide.
And jump in with questions too, by the way.
Yeah, so
okay?
if anybody
has
any
a formal
questions,
presentation, just shout it out, okay?
That's right. If you have any questions, feel free to ask them as we go along. It's hard to remember if you make your way all the way to the end. Excuse me. So first we'll start with what is a power of attorney. It is a legal document that authorizes another person to act on your behalf. Some of you probably already knew that. One way I like to explain it to clients is that it's a document where anything, when you sign a power of attorney, any document that the principal, meaning the person giving the power of attorney, anything that they could give legal effect to by signing their name to it, the power of attorney authorizes their agent to do it on their behalf. Okay? There's two main types. Excuse me. There are two main types: financial powers of attorney and healthcare powers of attorney. And we'll jump to the next slide. And I covered a little bit of that terminology just a second ago, but we'll cover it one more time. So the principal is the person who's granting the authority under the power of attorney. They're the one, once they sign the power of attorney, they're authorizing that person they designate, who's called the agent, to act on their behalf. So you got the principal giving the power of attorney and the agent receiving the authority under it. And so who can you name as an agent under the power of attorney? And you can name anybody. It can be a relative, friend. Oftentimes it's a spouse or a child, but it can be anybody. And it can be any number of people. You can have multiple agents on a power of attorney, 1, 2, or even 3. If you have multiple agents, you have to make a few decisions. A couple of those are whether the agents have either joint authority or several signing authority. Joint means that when they go to act, they have to act together, that both agents need to sign whatever it is that whatever business they're trying to transact, they both have to approve it and they both have to sign off on it. Whereas several signing authority means that either you're granting both of them equal power and either one of them can act alone on one signature to do the things that need to be done. Which is useful sometimes if you have, say, 2 children and one of them, you want to give them equal authority, but one of them lives near you and the other one might live out of state, then that several signing authority just makes things logistically a lot easier to handle.
Having your agents be several too avoids the situation where the kids might not exactly agree and then they're actually not able to accomplish what you hope they would by giving them the authority.
True. And you can also have a primary agent and an alternate agent. This is also very common. A lot of times people will name their spouse as their primary agent on a power of attorney, but because you tend to be about the same age as your spouse a lot of times, that person may die, so you have an alternate agent named so that you don't have to run out and do a new power of attorney. And usually you can give the alternate agent, who's oftentimes one of your kids then, the authority to certify to anybody receiving the power of attorney that the primary agent is either incapacitated or has already died or whatever. So they may be able to continue using the power of attorney just by presenting, for instance, a death certificate of the spouse.
One thing you should know about financial powers of attorney, ours are about 14 pages long. They have a lot of legal mumbo jumbo in them, and they're very powerful. So we threw up this slide here where a teenager saying, "A raise in my allowance is fine, Dad. What I'm really after is power of attorney," because basically with most powers of attorney that we draft, we try to make them as broad as possible. So what we've done is taken real life situations over a number of years of practice, included those in our powers of attorney. So we know what certain banks may have objected to in the past, or certain transactions, the troubles that someone might have come across trying to use a power of attorney. We've included those in our models. So now it's very long, it's very broad, and if you do give them to your kids, they can basically sign your name to anything. Now they're supposed to do it as your fiduciary. The whole idea is that they're going to do it in your interest. They're not supposed to drain your bank account and go to Aruba, right? But theoretically, until someone would stop them and revoke it, you're giving your agent really a wide breadth of authority. A couple different types of powers of attorney. The most common is a durable power of attorney, and that just simply means it's effective as soon as you sign it, and it's in effect until it's revoked. That's typically the kind that we prefer to use. Another type is a springing power of attorney, and when you think of springing, it means that it's not going to be effective until it springs forward in time, until some triggering event occurs. This is a more old-fashioned model, which we do not like to use. Typically, in the past, some people would use these in a case where they only wanted to give their agent authority if they were mentally incapacitated, for example. Now, the hard part with that is who's going to decide when, for example, mom and dad, who might be in their 80s, might be suffering from early onset dementia, Alzheimer's, when they're at the point when they need their kids to be acting as agent, right? Well, the kids might have one opinion, that person might have one opinion, and a judge might have a different opinion, and that's what's going to happen in that case, is you're going to have to go to court, file a petition, and get someone to say, with listening to your physician as an expert, yes, so-and-so is incapacitated, therefore they can use the power of attorney. That really cuts against what you're trying to do, which is to enable someone to transact business on your behalf quickly and easily with a power of attorney, and that's why we use a durable power of attorney more often.
I'll jump in real quick on that. I can't tell you how many times I've had over the years where clients have wanted to have a power of attorney drawn up for one of their parents. They might already be in the hospital or in the nursing home or whatever, and you ask them, you start getting to the question of, well, are they capable of signing a power of attorney? Will they understand what they're signing? And a lot of times the answer is, well, she has good days and bad days, and right now she's good, but who knows what it's going to be like next week. So you can understand how hard it is to determine when that triggering event has occurred when you use a swinging power of attorney, because that's often the way dementia is. It's sort of a gradual slide with 2 steps forward, 1 step back, and whatnot. So that's why we don't like to use springing powers of attorney much anymore.
And the other reason is you lose some of the practicality. Oftentimes, powers of attorney are used for if you're traveling and you need your kids to access your safety deposit box at a bank for some reason, or to help you with a car or a lease, or to sell something for you. All of that can be accomplished with a standard durable power of attorney. Even if you're competent, you just might not be in town. A couple examples of powers that we typically include in a power of attorney. We give our agents authority to write checks from your checking account. They can sign your name. They can transfer money between your bank accounts. They can purchase property. They can mortgage property for you. They can buy or sell a car. They can sell your house for you. Basically make any decision that you can make for yourself is how typically we draft them. They can even gift your money, which we intentionally do because in certain end-of-life situations it might be very beneficial for money to leave your estate and go to others, and this allows them to take that action for you.
So on healthcare powers of attorney, we'll move over from the financial power of attorney realm over to the healthcare power of attorney now. And healthcare powers of attorney are much shorter than the financial ones. Excuse me. They're only a couple pages long, and they deal exclusively with healthcare issues. For example, they can deal with granting your agent the authority to sign the admission papers to get you admitted to a hospital or discharged from it, or getting you admitted to a nursing home or a residential care facility. It also deals with giving informed consent for medical procedures, or making treatment decisions, or hiring or firing any healthcare providers. There are others on the list, but those cover the main things. Here's the key with healthcare powers of attorney. They only become operative when the principal is unable to communicate their own wishes with respect to healthcare issues. If your doctors and your nurses can speak to you directly and ascertain your own wishes, they don't even look at the healthcare power of attorney. They want to know what you want. And so the healthcare power of attorney really only steps into that void. Oh, yeah, and we have another cartoon about I never want to live in a vegetative state dependent on some machine. If that happens, just unplug me, okay? So she unplugs the TV. If this cartoon was being made today, it would be with taking the charging cord away from my kid with their smartphone.
Exactly.
So. that cartoon was a lead-in for advanced directives. And nowadays, it used to be advanced directives were on a separate form, but the General Assembly, the Pennsylvania General Assembly, changed the statutory form that we use for doing healthcare powers of attorney and advanced directives about 7 years ago or so. Now they're basically on one form. They can be separated, but it's actually easier to do it that way. The advanced directive language is actually a 1 or 2 paragraph portion on the second page of the healthcare power of attorney, but it's a separate thing. It only deals with your wishes with respect to emergency medical treatment when you are in one of 2 specific conditions as determined by at least 2 doctors, and that part is mandated by the statute. You have to have 2 doctors certify that you are in one of these conditions before they look at the advanced healthcare directive, which is also called the living will.
So when you're signing an advance directive, basically you're choosing to go down one of 2 roads. And most people in our experience, Keith and I have been practicing collectively over 43 years, and probably 95% of the people we deal with choose one road, which is you're evidencing your intent as what you would like your medical providers to do if you're in that condition, so that 2 physicians have indicated that you would pass away, but you're being artificially kept alive. In that case, the road most people go down is they indicate they would like to die peacefully with pain medicine, okay? But basically don't keep them plugged in is one of the choices, and most people, in our experience, choose that path. Another path which you can choose is to indicate that, no, my intent is to keep me alive as long as possible. And that might be contradicted by pain medicine, so then you're asking your medical provider, maybe we can't give that morphine because that might cause them to die, but keep them alive, keep them plugged in the hopes that they might find a cure. And there's actually been a number of well-publicized cases. The Schiavo case was years ago, where this came up, where some family members, maybe a spouse, is saying, no, keep mom alive, right? Or keep my spouse alive. And the kids might be saying, no, it's time to let them pass. What you're doing by signing and having an advance directive is you're saying, no, that's my choice. I'm going to make it now while I'm competent. I want everybody to know this is what I want. I either want to go down one road or go down the other, but you get to pick. And that's why that's such an important document.
And you can see the 2 instances when the living will comes into play. One is when you're in a state of permanent unconsciousness, which is when you have no expectation that the patient will ever regain consciousness, and then terminal illness when they're expected to die regardless of any medical treatment given. Every once in a while I have a client, it comes up often enough that I'll mention it, where a client will ask, well, if I sign this and then I get into a car accident on the way home, does that mean they're going to let me die? No. The reason why is because there's been no determination that your state of unconsciousness is going to be permanent at that point. Right? At that moment, it's just an emergency situation that they have to deal with. They might look to the healthcare power of attorney because you might be unresponsive, you might be unconscious as a result of being in that accident, so they might need the healthcare power of attorney to determine who has the authority to get you admitted to the hospital and make treatment decisions for you. But at that point, they're not looking at the living will.
And obviously, that's not a decision that any medical facility, Meadville Medical Center or otherwise, takes lightly. You know, before they're coming to the families saying, hey, look, this is a terminal condition, we've consulted with other physicians, it's our recommendation that you do this. You know, that's not taken at any quick moment, right? That's a well thought out recommendation by medical providers. Any questions on advanced directives and why they're such a good idea to have? That one other point on these is the hospital, whether it's Meadville Medical Center or another one, will typically supplement these with a form that they'll have you fill out if they think that you're going to be admitted and you're competent. And that's a more specific form that has you check certain boxes. We don't do that at our office. We wait until someone's actually presenting for medical care to do that. What that form will typically say is, I would like this, I would like that, I don't want this. And what you're doing is you're specifically going through medical procedures saying, in the event you're unconscious, you would like the hospital to do this, you would like them not to do this. Those change over time because medicine is changing all the time. We don't want to make a decision here in 2017 that someone's going to look at this form in 5 years, 10 years and say, well, wait a minute, they checked the box to not do this. Well, we have something similar. Should we be, you know, what did they mean? They didn't even know we could do this procedure. I could save their life. So we stay away from the check the boxes. And what we do is rely on, when you select your agent with a healthcare power of attorney, you're giving them the right to make decisions on your behalf. So what we see then is the medical professionals are going to be coming out of the operating room into the waiting room saying, we can do this, we can do that. all right? What would the person who you're taking care of want to happen? And then the agent gets to evidence that intent.
We need to close that dialog box before we move on. Okay.
Thanks. The next topic is wills. Everybody has an idea of what wills do, and this cartoon kind of captures what we hope to avoid, which is when someone's saying, I'm sure I can trust that you're not going to fight over my money when I'm gone, and then you have the three kids, one's got a baseball bat behind their back, one has an axe, and one I think has a candlestick or something, I don't know what that is, a chain, right? A ball and chain, right? Yeah. We do see a wide range of fact patterns and situations with families when it comes to wills. Sometimes it goes really well, sometimes it doesn't. But the whole idea of a will is making sure that what you would like to have happen to your money, your stuff, the people that take care of your children if they're minors when you're gone is what happens. And that you're not leaving it up to the government or the legislature with a very old statute that they wrote a long time ago, the intestacy statute. You're not letting that govern, okay? Or letting, hopefully, the kids fight over what happens when you're gone. Everybody needs a will. Again, you get to pick who handles certain things. You also get to pick the important people that will go into your personal representative. A lot of people use the term executor, executrix. Who's going to take care of the business of what happens when you pass away? You get to pick them. You can pick the trustee, who would be a person who takes care of money for kids, and the guardian, who might physically take care of your kids when you're gone. And again, you'd avoid those unintended consequences of letting the government decide.
So let's cover some of those unintended consequences. If you don't have a will, common misconception people have is that the government takes some or all of your estate, and it's not true. Every estate in the country has some form of intestacy statute. You can see where it's spelled there in quotation marks, that determines who gets your assets. Usually they're divided between your spouse, if you have one, and your children. If you don't have a spouse or children, then the statute digs deeper, and it will go either to your parents if they're living, or your siblings, and then from there on it goes down to nephews and nieces. It can even go down to grandnephews and grandnieces. I actually had that happen in a state that I just wrapped up not that long ago, where a person died without a will and had very few heirs, and we ended up contacting grandnephews and grandnieces that didn't really even know the decedent very well. That was an interesting phone call to make to notify them, because it was a fairly substantial estate too. So the unintended consequences of not having a will. Here is what Pennsylvania's intestacy statute says, and it's a little bit tricky. The intestate share of your surviving spouse, if you don't have a will, they get the whole thing if you have no children and your parents are deceased. So your surviving spouse would be the sole beneficiary. If you have surviving parents, then your surviving spouse would get the first $30,000 of your estate plus half of the rest, and then the other half would go to your surviving parent or parents if they're both living.
So that's where it gets confusing, is most people wouldn't think that, okay, I'm married, I die without a will. All of a sudden, now your spouse is, if you have parents who are alive, they're sharing with them. If you have kids, they're sharing with them. And it gets even more complicated, because if you have kids that aren't common to the two of you, the next two examples, show that basically you're going to be sharing a portion and a portion. And a lot of spouses are surprised by that, where they thought, well, I was married, I thought my wife would get everything. No, she won't, actually.
Yeah, if you have stepchildren involved, in other words, if you have kids, but they aren't also the kids of your surviving spouse, then there is no $30,000 off the top. It's just your surviving spouse gets half of the estate, and the other half is split amongst the kids. So this probably isn't the way most people would do it if they drafted a will themselves. So it's useful to know that as background information, because it really can be the impetus for a lot of people to get wills done. Okay, probate versus non-probate property. When you have a will determines who gets your probate assets. And what your probate assets are any assets where you have to look to the will to determine who gets it. Because there's lots of situations where you don't have to look at the will to determine who gets it. For instance, a life insurance has a contractual beneficiary designation, and that the proceeds of that policy go to that beneficiary regardless of what your will says. Same thing is true a lot of times of IRAs or annuities or bank accounts that have either a payable on death designation or are just jointly titled with somebody else. If somebody else is a joint owner on the account, that's also non-probate property. The presumption under the law is that the survivor on that account is entitled to all the proceeds.
Just to give you a couple examples, just to simplify it, if you own something with someone else and it's evident by how you own it, if you jointly own a car, you have a joint bank account, you own a house as husband and wife, those are going to automatically pass. Those don't have to go through the will. But things that you own yourself, like stocks, if you have a checking account with just your name on it, some guns, things like that, those are yours, and those are going to have to go through the probate process. But a number of people think, oh, probate, we try to avoid probate. Probate's really not complicated in Pennsylvania. It costs a few $100s to take you to the courthouse, get you sworn in as a personal representative, and then the process just involves all the business of the tax returns that have to get filed, but it's not unnecessarily expensive as many people might make you think or prey on you when they're trying to sell you very complicated trusts that you really don't need in most circumstances. But some people you'll see on TV where they market, you know, a living trust that you absolutely need to sort out things so you avoid probate. In Pennsylvania, you really don't need those, and it's a waste of money for most people.
Jump to the next one. So one exception to the joint titling, what Gary was just mentioning about joint titling of assets, is when you own property as what's called tenants in common. And here's the difference. When you own title jointly with somebody other than your spouse, when you own property jointly with your spouse, the presumption is that you own as what's called tenants by the entireties, which is basically just joint tenants with right of survivorship between a married couple. But let's say you own property jointly with somebody other than your surviving spouse. You have to make a choice when you take the deed. Do you want to own it as joint tenants with right of survivorship or as tenants in common? Joint tenants with right of survivorship. Here's an example. Albert and Betty, say they're not married, they own real estate as joint tenants with right of survivorship. That means that the minute Albert dies, Betty automatically becomes the sole owner of that property, regardless of what Albert's will says. Okay? If they own as tenants in common, we have different names on here, but let's say Amber and Brian own real estate as tenants in common. If Amber dies and leaves a will leaving all of her estate to her daughter, Kathy, then Kathy, when Amber dies, Kathy now owns a half interest in that property that she owns with Brian. So if either one of them wants to sell the property or do anything with it, they need to get the signature of the other. Okay?
There's a quiz on this after.
Yeah.
That's actually about a month and a half of first year property class in law school, those concepts, so
Yeah.
it's okay if you don't get it.
Yeah.
But just understand that if two individuals own property as tenants in common, so if Keith and I own a parcel of land, if something happens to me, my share of that property is going to go where I said it's going to go, okay? Which can be good and bad. In certain circumstances, it can be fine. Sometimes it can get complicated. If, for example, I leave everything to my 10 children, well, now Keith is going to be partners in that land basically with my 10 kids, okay? So that's what you see that out at Connet Lake, for example, with houses that have passed down through the years, and now they have lots of owners because family members might have owned property that way. Conversely, if we had owned it as joint tenants, if something happens to me, the survivor now becomes the sole owner of that property.
It's good enough for you to know that when multiple people own property, there's some choice I have to make about how we're titling it. As long as you remember
Just
that
have the
much,
discussion, right? How are we owning this
that will trigger in your
together?
memory that you need to have the discussion. I do the tax sales for the county. When people come in and buy properties at the auction, when people haven't paid their property taxes and they end up going to the auction sale. And we always have people fill out a sheet when they're the successful bidder as to how they want the property titled. So we try to have people thinking about that while they're bidding so that they can tell us on the sheet so that we don't have to make a phone call to everybody when we go to do the deed later on as to how they want that designation done.
It comes up too when, if a parent wants to, say, put a child on the property, and maybe they have several children, but for whatever reason, they've decided this one might want this real estate, so they add them, but they don't necessarily designate it, right? And now if they're tenants in common, when the parent dies, right, it's not going to go to that other child who's on the deed with them. It's going to go to whatever beneficiaries, whether it's by will or otherwise, that parent didn't specify, right? So that's where you'd want to have it as joint tenants. Okay. Yes? Jump in.
We got
yeah.
two. We'll take them in turn. You can go ahead.
So can you designate this joint tenant at any given point in time, and does that kind of circumvent an inheritance issue?
Good question.
Pass and left something to you, you could inherit it versus you were just tenant and stuff.
Yeah, the deed needs to say, if you want it to be joint tenants or joint survivorship, it needs to say that on the deed. So if it doesn't, and you want to make it that way, you actually have to prepare a new deed and put it on record. If we're talking about real estate, is that what you were intending? Okay.
But if the people were alive that originally gave the deed, the grantors, then it's easy to fix, okay? You just put a new deed on record and change it.
So if I have a house that I own, and I own it myself, and my boyfriend is now living with me, common law, does he have any right to my house if something happens to me?
No.
Okay.
There's no common law in Pennsylvania now since 2005. So none on that basis, and also none, even if they were tenants in common, they would only own the portion of the house that they had. So if you want that to happen, if you have a live-in and you're, if you're in a significant relationship but you're not married and you want that person to get the house, you can do it a couple different ways. You can either add them to your deed, right, as joint tenants, and then when something happens to you, they'll get it, or you could handle it through your will. Either way, you can do that. But otherwise, no, they would be out, and if that person died without a will, it's going to go through the intestacy chain, and with a will, it could go to their kids or wherever they said everything was going. Was there another hand up there? No?
One quick trivia question I'll ask too. What happens if it doesn't say? You run into lots of deeds at the courthouse where there's multiple owners on them, but it doesn't say anywhere how they intended to hold title. The answer to that is the presumption under the law in Pennsylvania is that they own as tenants in common. So,
So they own an undivided one-half interest, which will go by each person's chain.
So can I ask a question then? If you have it willed to them or it's like, their name is on, like, what is the cost? You know, like, does that change things of how much it costs
To handle it,
to move things around? Yeah, like if you wanted to, like if the child's name is already on it, do they have to pay inheritance tax? You know, like inheritance tax or something like that?
do you want to jump in or
Or-
pick first time?
Or if it's in the will,
Yeah.
like how does that?
yeah, you're talking about if a deed is already titled a certain way,
So
but
like currently, like my nephew is, if he gets my house if something happens to me.
because he's on the deed?
No,
Oh,
it's
okay.
not on the deed, it's in my will.
Okay.
As that, but like, will he have to pay tax on, like, how does that work?
Yeah, if
There will be inheritance tax, is the answer, yes.
yeah,
It's not inheritance tax, what's the relationship, a nephew?
no.
Okay, so there's different rates of tax depending on the lineal relationship. So spouses is 0, kids is 4.5, and then it kind of goes up from there and out. So there would be some tax. So theoretically, it would be less expensive if you added him, did a new deed and added him as a joint tenant with right of survivorship, because recording a new deed is relatively inexpensive. Probably be $60 at the courthouse.
Yeah.
Do you recommend like a time frame?
Well, as long, you have to, from the time, if you decide to add your nephew to the deed, you have to survive for at least 1 year past the date of that transfer, or else it's taxed as if the transfer didn't happen. Okay?
The
It's still-
one thing to consider is we do have situations where life is long and people might add kids or nephews and then say, oh, we're not getting along as well, or I'm not happy with their spouse and I wonder, you know, are they going to take care of my farm or my house? And people change their mind. So you can always change your will, but when you add them to the deed, they're on the deed. Yeah.
I don't have a follow-up question. Are you then equally responsible and recorded as far as property taxes?
Mhm.
When that deed is changed? So you would all receive,
One bill would go out,
Yep,
right?
yeah.
everyone,
Technically, theoretically, you're both responsible, right? But then you would be in a, I mean, I think if, you'd both be in a lose position if the taxes didn't get paid, right? Because ultimately, the property would get taken.
Yeah,
right?
the taxing districts don't care who contributes to the bill in what proportion. That's for you guys to work out, but they're only sending out one bill and you guys can work out how to split it, basically.
Something that we see a lot of too, it's related, is where parents oftentimes come in as they're getting older saying, well, I'd like to give my house to my kids. You know, how do I do that? And that's actually more of a complicated sit-down discussion, because As a parent, you might want to give the house to the kids, and you might be thinking, I want to get it out of my estate to save taxes, along the lines of that. But you also want to make sure you still have the right to live in that house for as long as you want. So there's ways to do that. We can, what's called reserve a life estate. So you give a deed to your kids, say I give my house to my kids, and then there's a paragraph in there that says that I have the right to live there for my natural life. So that gives you the right to live there just in case something happens to your kids, like they file bankruptcy or creditors are chasing them. You don't want to lose the property that you gave them, right? Because they got in a car accident and lost all their money, right? Or had some gambling debts, for example, when someone's chasing them. So there's ways to do that. You might be able to save some taxes, but it's actually a little bit complicated, but that's a common question that we do get.
What happens if the children or actually the parents trying to protect their child so that they end up going into a nursing home?
To protect the money that their kids
That
might
protect
inherit.
the house,
Mhm.
so that if they end up going into a nursing home, it doesn't have to turn it into the state.
Right. So your question is the tip of an iceberg, okay, with elder law planning, and it's hard to answer that because each situation is very fact specific. Generally, okay, there's kind of two ways to plan on that. When you're planning for people who have enough money that they're going to be able to afford some of those things themselves, the 1 or 2 years of nursing home care. That's one road of planning that we go down. Then there's the spend down to nothing road if you think that someone might be eligible for Medicaid. Now, to be eligible for that, right, you're going down to $2,000 in your pocket, right? That's a different type of planning, and there are some very good attorneys in town here who are certified as elder law attorneys, and really that's its own niche, because that's a make myself broke for purposes of the government plan, right? And you can't have it both ways. You can't keep some of the money and make yourself broke, right? So you really end up picking. And different roads work for different situations. But there are roads that you can do that by conveying real estate and other assets in enough time ahead of time, because there's a pro rata sliding scale, as you're probably aware, you've heard of that, with a look back period where the government's going to look back to see did I give away all my money so now I qualify for Medicaid? And obviously the government doesn't want us doing that, but you can comply with the law and save money. There are ways to do that. But that's a process where you want to be several years ahead of thinking you might need it, sitting down. If it's a spend down plan with a certified elder law attorney, or if it's a overall plan where you do have some money, because typically we find people that have saved their whole lives, they might have $50,000 in the bank, they might have 100, and they're worried about losing that. That might be a different type of planning than the one you're addressing there, which might be a spend down plan.
Yeah, the thing to remember from all that is if you wait to the last minute to start doing that kind of planning, it's usually too late. You kind of got to jump on it.
So more specifically, that's a complicated one. Okay. Yes?
What is the current look back time?
5 years.
5 years?
Yep.
But it's pro rata, okay? So just because you started planning 4 years before there's a triggering event, it's not that you don't get any credit, okay? You just don't get you get 80% of credit, right? If that makes sense. So there's no bad time to do it. Even if you're right up against it, still do it in the hopes that if you're going to go with a spend down plan, that you're able to get the benefit of that. Okay. Any other questions on that? Those are good questions. A couple key people that you're going to name in your will and that you can be thinking about. The first one's a personal representative. That's the person who's going to take care of the business of sorting out your estate, which will include final tax returns. Obviously, the government gets a bite of the apple of any estate you have, and that person handles that. They basically identify your assets, help us identify debts, make sure that people that are owed money get paid, and then communicate with your beneficiaries on what they can expect in the process. That's also the person that goes to the courthouse.
Yep. Yeah, I was just going to make a note that you heard him refer to the person as the personal representative. A lot of times you may have heard that same person referred to as the executor of an estate or the administrator of an estate. It's all kind of the same thing. Technically, an executor is what you have when there is a will, and an administrator is what you have when there was no will. The legislature decided that's silly to have different names for a person that's doing basically the same job, so they just kind of combine it. Now they're just referred to generically as personal representative. So. Yes?
Do you have to have somebody do that, or can your attorney handle that?
We generally encourage you to have somebody named other than the attorney. In very rare instances, sometimes the attorney will serve as the personal representative of an estate. For instance, if they have no family members and no friends and or whatever that they just don't feel like they can trust anybody to do it, but it's very rare.
And do you have to designate like a commission for them?
No,
in the will?
no. As far as paying them?
Yeah.
No, you do not.
State law allows a certain commission for the executor regardless of what the will would provide. Yeah. They don't always take it though. Just to expand on that point a little bit. If, for instance, you have 3 kids and you have a will that leaves your estate to all 3 of them in equal shares and you name one of them as the representative, in that situation, a lot of times the representative won't take a commission because if you take a commission, it's income that you earned during the year and you have to report it and pay income taxes on it. Whereas if you just let that money flow through to you through your inheritance, then it's tax-free because money you receive by inheritance is not subject to income tax.
If you're worried about a child, for example, one of many, doing that and taking a commission, you could always put a little paragraph in there that says, I'll be really, really upset if one of you takes a commission on this, right? Oops, we skipped guardian, sorry. So a guardian is, if you have minor children, this is really one of the most important jobs, is you're naming a person or persons who would physically care for your children if you were to pass. That role does not have to be the same person as the trustee, okay? So, and oftentimes we have different people because you might have someone in the trustee is the person who would take care of money. For anyone you designate in your will, it could be a minor child, or it could be a person who might have some issues, some substance abuse issues. Maybe you have a child who's dealing with something. You don't want to leave them money outright, but you want to put it in trust with a trustee. So normally somebody who's prudent, good with money, could handle managing money if it's a lot of money, or just be someone who can be, the person that can handle getting asked for money from the beneficiary. If they can handle that responsibility, they'll be a good trustee. That might be a completely different person than a guardian if you have young kids. You might think, okay, I have a sister who would be perfect and her house is ready and she'd be great to have my kids if something happened to me. She might not be the best with money. Then you pick a different person to handle the money. Any questions on that? That's it for wills, but we're open to questions. Before we finish, a lot of people are thinking, that looks complicated. How long does it take to do it? How much does it cost? One, it doesn't take a long time at all. Typically, it's one office meeting where we go through basically everything that's going on in your family, yourself. We learn about you, your kids, your situation, your parents, your assets. In about an hour and a half, we'll have what we need to draft them. In about a week, you can be coming back to sign everything. And it usually costs less than a set of tires for your car. Okay, so depending on, if things aren't too complicated, it's not going to cost an arm and a leg. Yeah, I'm tire shopping right now. I'm not shopping. I know where I'm going, but they're not cheap, right? All right? But anyway, my point is it's not terribly expensive. Most people, a husband and wife, are going to spend less than $500 to get all those documents put in place, and then you don't have to think about it for a number of years. If you have split families, or if we do get involved in some of the trusts that we told you that most of the time you don't need, but sometimes you do, and if we get involved in that, it's obviously more complicated and more is required, and then it will cost a little bit more. But what we've tried to do, actually, at our firm is we found a number of people hopping online saying, okay, why don't I just print off something from one of the websites that you can do that. And that really makes us cringe. One, because when we looked at the pricing, we actually charged the same, right, which we've done intentionally. But two, those aren't really tailored to you, both to state law and your personal circumstances. It's just not something that can be done by a form coming off of a website. So we encourage you to, you certainly look at it if you want, but then get in touch with a lawyer that you trust and that you're comfortable sharing, your personal details with, because obviously you're talking about naming, one, where you want your stuff to go, right? Who you want to take care of your kids, right? And those are deeply personal things. You have to be able to share what you have in the bank, because it would be malpractice for us not to ask you those questions, because if you had over a certain amount and we didn't ask and we didn't take certain steps in your will, we could be really causing you to pay taxes that you don't have to pay, right? So we need to know that. So we ask you about your debts, we ask you about your assets, we ask you about your situation with how do you feel about your kids' spouses? Should we be worried, right? Should I be protecting what you might be giving them in an inheritance? So it's very personal, but again, it's very important, and it takes about an hour of your time to get these put in place, and then you don't think about it for a number of years.
I do have a question. Who do you recommend, like, the will be kept? Because I found out my father, he had it in the safety deposit box, nice and safe, and then,
You couldn't find it.
yeah.
Yeah, we recommend we keep it at our office in a big safe, actually.
Your children who are power of attorney, should they be the one to have a copy of your?
Yeah, what we do, ma'am, is we give everyone a choice, okay? They can take the original, but like you've indicated, we need that original when it's time, when someone's passed, and oftentimes you can't find it. So we oftentimes keep an original and we give them copies. They share them with the family members that they would like. We do give back the originals of powers of attorney and advanced directives. We keep copies. And actually a photocopy works for 99.99% of the things with a power of attorney. The only time it doesn't work is actually if you go to the courthouse to
Record a deed.
record a deed. That's the only time you actually really need an original power of attorney, so a photocopy works fine. So if you have 3 kids, you want to name them as agents, as alternates to your spouse, for example, which is very common, right? Most people pick their spouse as their power of attorney, and then they might name their kids as alternate. We give them all copies. We have a copy. If it gets lost, we can produce another one. But with the will, we like to keep them in our office. Good question. Yes?
I made a will, drawn up by an attorney 20 years ago, and it just says, everything I have goes to my 4 kids.
Mm-hmm.
But a couple of years ago, it was on my birthday, I gave my kids a birthday present of a PowerPoint and told them all kinds of things, my obituary, where did I work.
Mm-hmm.
I took pictures of vases, that was my grandmother's and that type thing. The PowerPoint is only good if the kids agree to it, correct? The will, saying everything will be split 4 ways, is really what is legal. True? I'm not
I
trying to
would
just-
say that's probably true.
It's probably
Yeah.
true. We're not sure what your will says, but we're both nodding because the will would trump any inconsistent PowerPoint or memorandum or letter that you might leave saying, I want so-and-so to have the red plate. If your will says otherwise, the will's going to trump that.
A lot of times our will has a clause in it that we'll discuss with people at the first appointment that says, kind of similar to your presentation, your video presentation you did. It says, I may leave either a signed or unsigned memo with my will that lists specific items of personal property that I wish for certain people to have, and I request that my personal representative follow through on those instructions if such a memo is found with my will. Now, it's technically not, that memo that you write separate from your will and enclose with it is technically not legally binding because it's not part of the will itself, but it's in your own handwriting, and generally the family recognizes it to be an expression of your wishes. So probably 999 times out of 1,000, those things get honored without any incident being involved. And the good thing about doing it that way is it gives you the flexibility because you're always acquiring stuff and getting rid of old stuff. Mm-hmm. And as those circumstances change, you can change that list and put in a new one once in a while without having to come in and pay us to redo your will all the time.
And I have done that.
Mhm.
Okay.
That's good.
So you don't recommend to have that handwritten thing part notarized or anything like that?
It doesn't.
It probably doesn't matter, yeah. Because even the will technically doesn't need to be notarized. It just makes it easier to probate if it is.
Mhm. Those are good questions. Yes?
I came late, but.
Sure, jump in.
Did you talk at all about trust, especially, I don't know how that works out, I have little boys and didn't know how that's something anything you're playing with.
Sure. So what we talked about a little bit on that subject is generally, okay, for most people, you don't need separate, large, complicated trusts, okay? So if you have minor kids, the way we handle trusts are we embed them in the will, okay? So there's a paragraph in your will that says if something happens to me and if you're married, my spouse, so if the kids are inheriting, if they're below a certain age, that what they would receive goes in trust. And something, for example, to tell you what you could include is a lot of parents think, well, I don't want my kids to inherit, whatever amount of money it might be. If it's $100,000 at age 18, because they're not going to know what to do with it. So oftentimes we put in tiered age triggers, okay? So you could leave the money in trust with your favorite aunt or uncle for the kids, and you could say that at age 21, they get a third of it. At age 25, maybe another third. 30, another third. Those are common ages that clients pick. In the meantime, your trustee can use some, all, none of the money for their benefit. So health, education, support, probably not to buy them a Porsche or a brand new truck if they're 16 years old, but if they have a real need, the trustee can use that money. So for most people, you don't need a large, separate, complicated trust. For millions of dollars, you do. But for most people, you don't. Does that answer your question? Or? Okay. Well, thanks. Those were great questions.
My parents' will is like 51 years old and never changed it, like we even got guardians still and some stuff. Is that going to be relevant if something would happen to them? Or should they be updating that and taking some of that stuff out? Does it matter?
Do you like what it says, or?
No, it's fine.
I'm teasing you. I'm teasing you.
He's still in charge of me, like I'm 55 years old,
Yeah. That's going to be complicated for you later. Yeah, it's probably fine. There's probably just a lot of irrelevant sections.
What does that pay attention to?
Yeah, they would just get ignored. From a practical standpoint, it probably was done, if it's that old, it was probably done before wills were commonly notarized, which might make it a little bit trickier to probate, might make it a little more expensive to probate because you have to find what are called either subscribing or non-subscribing witnesses that can attest that it's that person's signature on the will, whereas if everybody's signature is notarized, you bypass all that. So, it's probably good enough, but if they wanted to remove that one little layer of issue, they could go ahead and get it updated.
Because they've been thinking about this stuff, we've had a lot of, everybody's older, and they've lost siblings. So they're definitely on the right track of thinking about it. I just don't think they've called their attorney and said, we need to sit down and clean some of this stuff up.
And really, it would not be a big deal to do that, particularly if they don't want to make major changes. It's just simplifying it, as Keith indicated, getting witnesses, having it notarized, so that when something does happen, it's not procedurally difficult to handle. Yeah. Yes?
Going back to living will,
Mhm.
And television and whatnot, there is DNR.
Yeah.
Can you explain sort of where that fits in relative to living will?
Sure. So the DNR is the form that typically the hospital will give you. That's the more specific check-the-box form. And the hospitals want that really because they don't want to have to be wondering what you wanted or didn't want. So if you're mentally competent and if it's a planned visit to the hospital, they're going to have you fill one of those out. That supplements your Living Will Advance Directive, okay? In your Living Will Advance Directive, you're still indicating your agent, okay? So when you are unconscious, they're still going to go to that person to ask what healthcare decisions should they be, taking on your behalf. And likewise, it doesn't change your end-of-life intent, okay? But it might add layers, right? So they might then take some of those actions. If you check the box, I want this, I want this, I want this, now the hospital is going to have to look at those, okay? So that could be a little bit complicated, but they would actually look at that and they would follow that. Did you want to add anything to that?
No, that was good.
Okay.
My elderly mom, my family and I are in the process of moving her back from Florida, and she's going into assisted living. But what we're running into with something, with her having been in Florida, is like, say, some of her accounts or bills and so forth, they won't talk to us because, you just talk to her. But yet we are power of attorney and everything. So is there any way that we can work around that, via phone calls or something like that, instead of, like the phone system, instead of, or provide them with a copy of it?
Have you done that? They're not accepting the power of attorney from here?
We've voiced that, but they usually just say, nope, we need to speak to her. And thankfully, we've been able to help her do that, but we are running into that.
Have they requested that you forward, like either email or scan a copy of the POA down to them?
One place let us, but most of the places won't even talk to us. It's just like utility things and banking and that.
Is it?
Banking we were able to do with our power of attorney copy, but it's been a little bit challenging because of us being in Pennsylvania and not in Florida.
Right.
So,
And she's still competent,
Yes.
your mom?
Yeah.
Yeah, we have had that on occasion with other states. Normally, if you went to your attorney, they could push through that. At worst case, you could also probably relatively inexpensively have a Florida attorney do a POA, and then you'd be presenting a Florida institution with a Florida POA.
That's actually where her will and everything was made up, so maybe have them call these places if they need to.
Mm-hmm. Yes,
Could probably work.
absolutely.
Yeah.
Mhm.
Okay, yeah, 'cause there's a couple in my.
Yeah, if they had a Florida law office do it, that office can call it and push through those obstacles for sure.
Yeah, that can happen sometimes if you're dealing with a financial institution that mainly operates in another state and they're not familiar with the power of attorney form from another state. They get kind of set in their way sometimes.
Yeah. Okay, and, that spend down, like the 80%, would you elaborate a little bit more on that? You said something about 80%.
So just generally, there's the 5-year look back period, okay, for asset calculation and eligibility for Medicaid. And the point is a lot of people will come to us when there's not 5 years left to plan, okay, for various life reasons that it kind of snuck up on them. It's still never too late because you're going to get a portion of the benefit, okay? It's not an all or nothing at the 5-year window is what I meant.
And do you,
We would actually recommend, most cases, we would meet with you and decide if that is the path, a spend down path, and we'd refer you to someone who specializes right in that. Ty Cressman in Meadville is excellent at that. Mhm. Ty Cressman? Yeah, we work with him a lot on those cases. Good questions.
The person dies, the power of attorney is over, correct?
Yes.
Yes, and actually that's a good question. That leads to another point we probably should cover. When the person dies, that power of attorney expires on their death. However, that means nobody has the official authority to act on behalf of that person until the personal representative is appointed under the will. And so you end up with a little window there where nobody really has the authority to get anything done. A lot of people think that you can just take the will to the bank and see it says on the executor, so that should be good enough, right? And it's not, because you have to have a certificate from the county's Register of Wills office that says that you've been officially appointed as the executor, which means the original will was taken to the court and probated. And then they'll give you several certificates under the seal of the Register of Wills office that you can then use and take it to the banks, the post office, and wherever else you need to deal with people.
I know you said you would recommend someone else for elder law, but I've been through this, what we're talking about with my father and then with my mother. Now, went through the spend down things and went through the Medicaid. And now, how many years do I have to keep the documentation that I've had as being the executor of their estates? I mean,
You mean just your copies of keeping it?
Yeah, their legal documents, I mean, everything that they had.
Are they they're gone now, so it's gone through the estate process already? So someone handled an estate for you?
Right.
And presumably the correct tax returns were already filed and approved by the state? Everything's done?
Do I have to retain that same?
Not,
Yeah, I had a client
a little
call me on
while,
one
right?
of those
Yeah.
questions not that long ago. I mean, I know that the federal tax returns can be audited back 3 years from the time that they were filed. So you want to probably at least wait that long because presumably you had final income tax returns that needed to be filed for the decedent. So it's a good idea to hold on to the paperwork at least that long. After that, probably can start getting rid of most of that stuff.
you could also check the attorney's office probably scanned everything and is keeping it.
Right.
We do forever because things come up. We get phone calls 20 years later and it's, can you talk to us about what happened or didn't happen on that estate?
A lot of times your copies are redundant copies, and like you said, a lot of times we have to go back and look up information from estates we handled a long time ago, so we hold on to pretty much everything. But it's a lot easier now because we don't have to have so much storage space because most of it is scanned.
Well, thank you all for your attention and time and great questions. We appreciate it.
Yep, thank you.
Thanks. We have copies for the PowerPoint if anyone wants it, but thank you. Thanks.
Okay.
Good night.